Welcome back, everybody, to the Aaron's High Cap Adventure Radio program. It's April 27, 2019, and to my left sits attorney extraordinaire Benton Ross Watson. The Watsons in the house. What's going on?
What's up? Snap into his lip, yo.
How you doing today?
Man, I'm fired up. I there's so much to talk about with this Ninth Amendment, and man, I know I have this love affair with the Bill of Rights. I mean, I really do. I have this just infatuation. It's almost I think it's a sickness, but because every time we come on here, I go, "This is my favorite amendment." But
No, I wouldn't call it a sickness. I would say you're very healthy. It's the ones who don't appreciate those amendments that are sickly.
And man, this one is used much more in the courts than the Third Amendment that we got, but they're along the same lines. And in the last 30 years, this Ninth Amendment has been debated probably back and forth. Obviously, it may not have huge implication, but on a scholarly level and in the world of academia, it's probably been debated more than any other one of the amendments.
I can see that. I should probably read it. But
Yeah, we're gonna read it. I just, it's got so much to it, and there's so much interesting backstories. I mean, I can't even get into all of them, but go ahead.
The Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, let me give my quick analysis of that, and you tell me if I'm right. Basically, the Constitution's written. This is what you can do, what you can't do, blah, blah, blah. But if we forgot something, if it's not in there, it doesn't mean it doesn't exist. Is that correct?
A little bit.
So you may have some rights that we may not have put in there. It doesn't.
Correct. So I mean, that's part of it. Yes. So you remember from day one, and when we really got into the Third Amendment and we got into the Fourth, and how I get passionate about the rights ordained by God.
Yes.
How there's inherent rights, how there's individual rights that cannot be taken away from man.
Correct.
And that goes back to the Magna Carta. I mean, that we had in that Constitution, and it goes back further than that. But I mean, from the roots, from the roots of the soil that we are on right now. That's why we are what we are, and that is why we are so great.
Can I ask you a question? Where do you get your passion from? Your patriotism, your patriotic passion from?
I lack sleep.
No, that was a serious question. I get mine because I was raised in a family that my grandparents came off the boat. They were so appreciative to get here. They went through the process legally, became American citizens. My parents were firstborns here. They love this country. Great pride, into politics, and not politics in the sense of the way you see it now, politics in the sense of getting the right person in there, understanding your rights and all this kind of stuff. And I've got it swelling in me and coming out of me. I'm just curious because you're very passionate about it.
Well, this is a good explanation. A lot of people think that I used the name Benton now because I'm trying to be fancy, or I'm trying to be somebody I'm not, or I don't use some kind of marketability, but really, there's 5 generations, possibly 6. It's hard to trace my family back, but generations of Bentons, and every single one of us was adopted.
Oh, wow.
And most of the time, except for my dad, because he hated the middle name Lamar, but for most of them, they didn't use the name Benton until the predecessor died. Okay, and so the reason I'm telling you this is because every time, it's like our generations have had to start over from scratch. And so my grandfather had to go from an orphanage in Alabama and then to family in Louisiana, and then just made his own way out in West Texas. And my dad was adopted and had some hardships, and he had to make his own way too. And I guess it's just kind of that capitalistic, tough nature that I appreciate having the rights that I have and being able to do that in a country such as this.
Amen, brother.
And I mean, it just goes to show you that, I mean, because every time that this happened, they were in a situation where they really didn't have a lot of help, but they've always ended up being successful because they worked harder than everybody.
Not to get too personal, was adoption because they felt that was a way to get somebody out of an orphanage and to help them, or was it?
Some of it was that, and some of it was family. So some family died, and then.
I got you. Okay.
So, but here's the thing with this. We talked about the natural rights ordained by God that man has, and you cannot take away from him. Okay, and so that's what we were trying to protect with these Bill of Rights. And remember, Rick spoke about it. And I spoke about it too. There was an anti-federalist and the federalist, and the federalists, such as Alexander Hamilton and James Madison. Right, did not want, and Justice Marshall, who's one of my favorite justices of all time, right, did not want the Bill of Rights in there because if the rights cannot be taken away and government already doesn't have that power, when you try to go in there and list them, okay, then you're going to raise an issue about, well, since you didn't list these others, that means that we don't have those rights. They can be taken away. And so I actually...
these guys back then, and I'm sure there's people like this now, and I know there is, but it's just forming this and writing this and thinking of this in advance. It's just unbelievable.
Yeah, so if you're listening now, stay tuned, because it gets interesting. But Alexander Hamilton said, "Why declare that things shall not be done which there is no power to do? Why should it be said that liberty of the press shall not be restrained when there's no power to restrain it?" And he's right. And then so Madison goes further and says, well, if you don't then list everything, right, you're going to subject those to the government. Because he understood how governments interpret, right, their power, that the anti-federalists weren't really trying to, and that's what Rick was talking about. So the anti-federalists, they probably were advocating for the Bill of Rights to some degree, but
I was just going to say that.
What they really wanted was to undo the Constitution because of things like the Supremacy Clause. Okay, that was wide and sweeping. Congress has the power to do all things necessary and proper. Okay, and then there's the Supremacy Clause, and they called the Necessary and Proper Clause the Sweeping Clause. Okay, because it gave Congress a lot of power. Okay, to do whatever they thought was necessary and proper, right, for the government. And so the anti-federalists wanted to undo it, and they did not want ratification to go through. Okay, and they wanted to kill it. They wanted to bring sort of like a referendum and undo it, and then limit the Constitution. So they were really trying to raise stink because they didn't want this. They wanted to reverse some of the things that had happened. But then Madison and these guys start to get smart, and they compromise, they keep compromise. Okay, we'll do that. We'll offer this Bill of Rights. We'll offer this one. We'll offer this one. And you got to remember, we talked about the jury trial. The jury trial is not an inherent right. That's not something that is ordained by God. But that was something that was necessary, okay, to protect those inherent rights.
For reasons that you explained, totally.
Okay, and the lawyer part of it, okay, could arguably said to be not right a right that's ordained by God, okay, arguably, okay, but it was necessary in order for you to preserve that right. Now the First Amendment, that was something that was absolutely, and that scared James Madison to put the First Amendment in there. It scared him to put that in there because he could reconcile putting the jury trial and stuff like that because that was more government procedurally oriented, right? But when you start putting things that you already have a right to do, it gets scary because it makes the government think, well, they can take that away if it's not in there. And so I'll even tell you this, like they had so many debates about it. And so if you remember Rick too, he said that two of the amendments did not pass. One of them was, I think it had to do with payment to certain legislators, and I say legislators, congressmen, which later passed, I think, in the 27th Amendment. Okay, but I don't even remember what the other one was. But the 9th Amendment was actually the 11th. Okay, and so it scoots down to, but they have a bunch of arguments about this, and I believe it was James Iredell who's later going to be. He's right now. He's really more of a politician than he is a judge, but he's going to be a good justice for the Supreme Court later. Justice Iredale says in the North Carolina ratification, he says, for every single one you try to list, okay, in the Bill of Rights, I can name another 20 or 30. It's impossible. It's impossible to name all the inherent rights that we have that government cannot take away from us.
Did they list the certain ones because they?
Yeah, they're in the Bill of Rights. They're in the 10.
No. What I'm saying is, did they list the certain ones like the freedom of speech, the right to defend yourself, because those were so prominent? Everybody saw those, whereas the other ones, that the 20 that he could say for everyone you got, I could list 20. That those, they're there, but they don't really come into play as often as these other ones do. Maybe they're saying we just want to protect them.
Correct.
Second, double down on them.
So that kind of goes into why it was the 11th Amendment instead of the 9th. But James Madison originally had the 9th Amendment. He wanted to throw it in right at the end of the Constitution. He wanted to kind of amend it, modify it. He wanted to throw the 9th back in the document itself as a preamble to let everybody know that
this would be this right here. I'm looking at the preamble of the United States right now. And I'm asking you. They want
this would have stayed, but he wanted to throw the 9th in there as a preamble to another article, or even make some of the things articles themselves instead of making them amendments. But you'll like this before. So when they were arguing about the topic of what the 9th Amendment protects for us, you're going to like this because it was before the Second Amendment actually was pushed through, and it's James Wilson arguing that he says government, in my humble opinion, should be formed to secure and enlarge the exercise of natural rights of its members, and every government which does not have this view as its principal object is not a government of the legitimate kind. And one of these rights is the defense of oneself, justly called the primary law of nature, is not, nor can it be abrogated by any regulation of municipal law. He's talking about the right to self-defense. He's talking about the right to self-preservation. That was thought to be a naturally inherent right, which we talked about in Scalia's opinion with the D.C. case.
Yes.
Okay, and how those rights to privacy were really inherent into that Second Amendment, right? That's why we needed that. And so, but there's more, and so this is when we get into penumbras.
Whoa, gosh, that's a $2 word for me.
This is where we get into the penumbral, okay, rights that we have. Remember, these are the twilight. These are the things that are rights that are implied by design, even though they're not specifically stated. And they're things like every day we use on a daily basis. Okay, I know you use your Second Amendment right on a daily basis, but I mean, everybody uses these rights. Their rights to privacy, their rights to family, their rights to procreate, their rights to direct religious and moral training and educational training of your children. There are things like the privacy and sanctity of your home, which, yes, is protected by the Fourth Amendment, but there's things about your home which are private that may not just be protected by the Fourth. It's more of a right to privacy. Okay, and so they go into things that touch the heart, what the Supreme Court calls it, touches the heart, okay, of the existing order. I mean, the existing order of things. They're things that we need on a daily basis, okay? And another good illustration of this is Rick pointed out, he talked about the Wilkes case. At the time of the founding, and we talked about when he was speaking about jury trial in the Seventh Amendment. Mm-hmm. Okay, he spoke about the Wilkes case. Well, what happened in the Wilkes case is that there was general warrants. Okay, that's why we have the Fourth Amendment now, because there were general warrants, and essentially the king, for tax reasons or for political reasons, could issue a general warrant. And by the way, those things usually didn't have a time limit. They were endless. And so you could get a general warrant, and it was almost like a favor. Because if you ever had to go after somebody, right, you could use it to attack that person. Mm. Okay, and so you could always have it as leverage over somebody's head. All right, and So what happened is Wilkes was part of maybe a group that was against those in power, and he owned a newspaper, he owned other things, he did publishing, okay, and so they got a general warrant, and they came into his house and rummaged through all of his house, tore his house to pieces, right? It was a big conspiracy. Apparently there was many people involved, but at the end of it all, and so this was not rare. This was things that happened, but this was at a time when there was turmoil, when everybody started realizing, like, man, I'm tired of the king stuff. I'm tired of Parliament being, overbearing. I'm tired of like not having. I'm tired of just the walls closing in on me and feeling like I've got nowhere to go because there's just so much, right? Just pressure, or we don't have enough economics. There's not enough for us to do because there's too much government control, and they can do whatever they want to. There's no liberty of movement. There's no liberty of thought. There's no liberty of imagination. There's no liberty of to be the kind of person that I want to be. And so that was a big push at that time in England. This was in England.
You ever read Sun Tzu?
Yes, we did. Yeah.
It says, always leave a back door for the enemy, otherwise they'll fight to the death. And what you were explaining there was it kept closing in on you to the point where it's rebellion.
Or really, the doors were always closed, but it finally was starting to come to a head. People were getting more educated. I mean, this was a time when there was starting to have some growth. And then you have the revolution in America, and that's starting to be sort of contagious, right? It hasn't happened yet, but these feelings are all happening at the same time. And so when we see what happens to Wilkes, he turns around and sues the government. He turns around and sues them for breaking into his house. And normally it would have been a futile lawsuit, but he ends up making this case, right, for these natural rights that government cannot violate. These natural rights that exist, okay, and are subject, right, to no politics. You cannot violate that. And so we had what we called Entick versus Carrington, and it was a famous case. And this case made it over to the founding and was a huge part of what they did. And he says this: the great end for which men entered into society was to secure their property. That right is preserved sacred and incommunicable in most instances, and is not to be taken away or abridged by some public law for the good of the whole. There are cases where this right of property is set aside by positive law, and these cases are various. Distresses, executions, forfeitures, taxes, all of these reasons are reasons why, right, government can come take our property. But, he says, but, by the laws of England, every invasion of private property, be it ever so minute, is a trespass. No man can set foot upon my ground without my license, but he is liable in an action, though the damage be nothing. Even if it's nothing, he's liable for trespassing into my privacy, right? Which is proved by every declaration of trespass where the defendant is called upon to answer for bruising the grass and even treading upon the soil. If he admits the fact, he is bound to show by what justification that some positive law has justified or excused him. The justification is submitted to the judges, who are to look in the books and see if that justification can be maintained by the text of the law or by the principles of common law. If no such excuse can be found to produce, the silence of the books is an authority against the defendant, and the plaintiff must have judgment. According to this reasoning, it is now incumbent upon the defendants to show the law by which this seizure is warranted. If that cannot be done, it is a trespass. And they couldn't. They could not show, right?
That was very clearly written.
Yes, and this was back. This was a long time ago. Okay, and this was in England. This was a judge in England. Entick versus Carrington is an English case.
I mean, I didn't have to decipher anything. It was just basically legit. I could understand everything.
And so you don't have a right to come in my house, right, when you've got no justification for it. You don't like me as a political enemy. That is a right politically. And see, that's something. Remember, we talked about political speech being core speech. Okay, we talked about that. So that is protected by the First Amendment. But there are other things that are still political that may not technically fall within that. It's got to be implied. Okay, and so it's not they're not specifically stated, right? Everything that we need as far as protection is not stated in there. And one of the congressmen even goes so far as to say, well, if you're going to list everything, why don't you just list how I put my hat on? What they were talking exactly like this: what shirt I'm going to wear today, what shoes I'm going to wear, how I'm going to walk, right? And that's true. Those are things that sometimes we take for granted, but they are things that go into the essentialness of liberty. And so there's another great case that, and I just told you, it's one of my favorites, and I couldn't remember the name, but the case is huge, and what happened there is they're essentially trying to subpoena a person to the grand jury, and they're trying to subpoena his papers, and the papers are what they want to prove the crime. And so this was kind of a case of first impression. This is a really old case, okay? And so there was an interplay, and a lot of scholars disagree with this decision, but I think it's a good one, and I like it. I use it. And it was, is it a Fifth Amendment? Is it a Fourth Amendment? Because you can't compel somebody, right, to incriminate themselves, and if they're writing and it's their own papers, okay, then that's what you're doing. But at the same time, you're trying to invade their privacy, which was a Fourth Amendment issue, but it was by a lawful procedure, and so was it something that couldn't be done? And so again, in my opinion, you can even say that this was a right that was implied, and at least it definitely shows the right to privacy. And here's what the judge is saying about those privacy rights. They reach farther than the concrete form of the case then before the court with its circumstances. They apply to all invasions on the part of the government and its employees of the sanctity of a man's home and the privacies of life. It is not the breaking of his doors and the rummaging of his drawers that constitutes the essence of the offense, but it is the invasion of his indefeasible right of personal security, personal liberty, and private property where that right has never been forfeited by his conviction to some public offense. It is the invasion of that sacred right which underlies and constitutes the essence of that Intick opinion that we just read. That is the essence of that opinion, and that is the essence of the right to privacy and the right to liberty. And so when they're not enumerated, when they're not specifically stated, that raises problems today. Because you got to ask, there was the right to free speech was something that the government would not have had a right to regulate back then. Mm-hmm. And it would not have even been, it would have been a no-brainer. Nobody would have questioned the illegality of them trying to censure somebody. And so, I mean, they may have questioned. There was a lot of tumultuous thing that was going on then, but there was this general understanding that was improper, okay? And so when I say that, how far does this go? Like, is it a fundamental right? Is it a right that's absolutely something that the government can't touch? Is it something that the government can regulate but not prohibit? Is it something that the government has a right to prohibit outright, or is it only able to prohibit it if you're hurting somebody in exercise of that right? Okay, and so a lot of these debates come up with the Ninth Amendment, and that's why the Ninth Amendment gives us troubles, because a lot of judges will say that the Ninth Amendment is merely an interpretation tool. It tells us, right, that there are other rights, and those aren't all that there are. Other judges would tell you that this is a source of some sort of inherent natural rights that we have. It is proof that they exist. And others would tell you that it is just a meaningless phrase that does nothing more than tell you that the states have the right to regulate it and not the federal government. But in my opinion, that's taken care of in the 10th, which is what we're going to talk about a little bit next time, and when we wrap all this up. But
So what's as a real quick summary of the Ninth Amendment, you're basically saying they put it in there to say, look, hey, before you make a decision on something, don't forget, just because it wasn't in there, think about it, debate about it, discuss it before you just make a decision.
This is what I'm saying. I can tell you my opinion, okay, but right now in the scholarly world, and it's gonna come out. This is why it's important. What the scholars eventually end up getting to is gonna come out in the Supreme Court. It's gonna come out in the appellate courts. It's gonna start being argued at some point. But right now, I guess all the lawyers are just kind of letting the scholars sort of just go after each other's throats, okay? Because there's at least 5, maybe 6 different theories about what exactly the Ninth Amendment means, and it goes into, is it collective rights? Is it individual rights? Is it more just the ability to govern yourself, or is it inherent rights, or is it some combination of one or more of those things? And so two or more of those things. And I would say this. I believe that if anyone goes and reads this, that they are going to see that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And so that tells us that the people are retaining, rights that were enumerated. They enumerated rights that were extremely important.
That's what I said earlier, yeah.
And so there would have been no way for the government to come in, right, and regulate the First Amendment and that be thought to be lawful. Okay? And so there's got to be also, and it wasn't enumerated. Did you understand what I'm saying?
Yes.
Before there was a Bill of Rights, the First Amendment was not enumerated.
Right.
It was understood that you cannot regulate that.
Right.
And so there are rights now that are not enumerated that it should be understood you cannot regulate. Or if they can regulate anything. They've regulated the First Amendment, but there's a difference in time, place, and manner in prohibiting people from doing it. Okay? The government has already tried to come in. That's why Griswold. So Griswold was about, and a lot of Catholics and people that disagree with abortion or don't like Griswold. It kind of falls into that camp that leads into the reason why they allow abortions to happen. But Griswold was an important case because it gives us an idea about what exactly our rights are. And so it said that they couldn't use birth control. It made it a crime to use birth control. I think it was Connecticut at that time. It made it a crime for a man and wife to use birth control. Now, what amendment protects that? Is it the first? Well, not really, because that's not really assembly, right? Is it the fourth? Not really, because the government's not invading your home. Right? Is it the third? No, because there's no soldiers in there. Is it the fifth? No, because nobody's telling on themselves. Is it the sixth? No, because they're not a crime yet.
It's the one that's not enumerated.
Right? What about the Seventh Amendment? No, because if we got arrested or if we wanted to sue somebody, we'd have a jury trial. Okay, what about the Eighth? No, it's not cruel and unusual punishment because I'm not really being punished yet. Right? It's got to be the Ninth.
Got it.
It's got to be one of those rights that James Madison was trying to tell us is not enumerated in the Constitution, but is as important as any of the other rights. And so, actually, Griswold hinged on the 14th Amendment, but they make their case with the 9th Amendment, okay? And it goes into say that the house is the sanctity and the privacy, and it is the most sacred spot, and for the government to try to get in between the relationship of a man and a wife is about as unfundamental as you can get.
Yeah. I'll tell you, I consider myself somewhat familiar with the rights, but as we're doing this week by week, I'm like, man, there's so much more behind it. But Ross, we got to cut it short. But look, I wanted to give you something. Ladies and gentlemen, I made some business cards up some time ago, and I've had a few left. And there's the business card, and you open it up, and it's got the Bill of Rights right there with the preamble. I made sure I put the preamble in there just for you, so I'm
I
going to
love
give you
it.
that.
I'm gonna lose it, man.
Tell everybody how to get a hold of you. And I forgot to tell you, this long segment is sponsored by Copley & Dodd Krebs Law Firm. Couldn't do it without them, as well as all the other sponsors out there. So tell everybody how they can get a hold of you, Ross.
105 East Main Street here in Cameron, Big Milk County side. Can't miss it. If you want to email us, we love emails on the show. It's benton@watson.legal, benton@watson.legal. Or you can give us a call at 254-605-4140, 254-605-4140.
Sounds great. Kincaid, take us out, and when we come back, we'll have delicious Janae Goodman talking pairing of foods.